1985, all petitions from Malaysia to the Judicial Committee of the Privy Council had been abolished, leaving the Supreme Court, Malaysia's apex court. The government was unhappy with some of the Supreme Court rulings during this time frame, such as J.P. Patterson against Director General of Immigration, Malaysia and others, and Public Prosecutor against Dato' Yap Peng. In the case of J.P. Patterson against Director General of Immigration, the Supreme Court affirmed the denial of an international journalist's work pass on the grounds that he was not denied the right to be heard when his visa was revoked. Furthermore, in Public Prosecutor against Dato' Yap Peng, the Supreme Court upheld the High Court ruling that Section 481 Clause A of the Criminal Procedure Code, allowing the Attorney General to pass cases from lower courts to the High Court, was unconstitutional because Article 121 of the Constitution vested judicial authority in the High Court. The Prime Minister made several public critiques of the court and some of its rulings. In an interview with Time magazine in 1986, he said, "The judiciary says, despite the fact that you pass a law with those aspects in mind, we think your mind is incorrect and want to provide our understanding. If the courts rule in our favor, we will interpret the dissent. We will forfeit our legislative authority if we continue. We have decided what we are going to do. However, if we do so, it's viewed in a different manner, and we have no way of seeing it in our own way. When we discover that a judge still casts us out based on our own view, if he interprets according to why we made the statute, we will have to find a way to produce a rule that would be read according to our wishes." And as a result, several judges in Kuala Lumpur rallied behind Tun Saleh to take action to put a stop to these public remarks. Tun Saleh then wrote a letter to the king requesting his involvement and forwarded copies of the letter to all the Malay rulers, but nothing seems to have happened that Tun Saleh was aware of. Tun Saleh was then summoned to the Prime Minister office, where he was told that the king had taken issue with the letter and required him to resign as Lord President. Tun Saleh agreed but ran back on his word the next day. He was also barred from carrying out the duties of the Lord President after the meeting with the Prime Minister. Under Article 125, a tribunal was formed and formal charges were found against Tun Saleh. Tun Hamid presided over the tribunal, and Tan Sri Abu Talib presented a case against Tun Saleh before it.
The charges were that the king had objected to Tun Saleh's message adjourning a particular case, being pro-Islamic in the reading and implementation of the rules, and by doing so creating terror and confusion among its non-Muslim community. At the end of the trial, the tribunal found Tun Saleh capable of not just misbehavior but also incompetence, rendering him ineligible to discharge properly the duties of his office as Lord President of Malaysia. The tribunal ordered that he be removed from service both as a judge and as the Lord President of the Malaysia Supreme Court. Tun Saleh asked the High Court for permission to seek an order prohibiting the tribunal form to advise the king on whether he should be excluded from deliberating and making any recommendations to the king from doing so. Due to the High Court's excessive delay in deciding the case, Tun Saleh petitioned the Supreme Court via ex parte notice of motion for an order preventing the tribunal from sending its report to the king. Since Tun Hamid, the interim Lord President who was chairing the tribunal and relief, was pursued against him and other judges of the tribunal, Tan Sri Wan Sulaiman, the most senior judge after Tun Hamid, decided to hold a meeting of a special sitting of the Supreme Court for this reason. The Supreme Court issued an ex parte order on 2nd July 1988 prohibiting the tribunal from sending any submission to the king. Tun Hamid was unsatisfied with this decision. He then petitioned to the king to have the 5 judges disqualified under Article 125 Clause 3 and barred from serving as Supreme Court judges in the future. The biggest charge leveled against the 5 judges was that they took part in an illegal sitting of the Supreme Court on 2nd July 1988. Wan Sulaiman and George Sia were both charged with staying away from the Supreme Court sitting scheduled for 2nd July 1988 in Kota Bharu without fair cause. The tribunal determined that the charges leveled against all 5 judges have not been proven. However, an additional charge was formed against Wan Sulaiman, George Sia, and their actions led to misbehavior under Article 125 Clause 3. The tribunal ordered that the 2 judges be suspended from their positions. As effect to the judiciary due to this constitutional crisis, Malaysia is far from having true separation of powers. The judiciary and executive remain inextricably linked. There are also judges who are concerned that their rulings and judgment will irritate the executive and thereby jeopardize their career.